Yes. Yeah.
Morning.
For motion, item number 1.
Yes, Mr. Kaushik, CD is available.
CD is available, madam.
My lord, the petitioner was arrested on 25/8, lordship, and produced on 26/8.
1 second. Arrest on 25,
25/8, lordship,
24.
24, and
And-
produced on 26/8/24, lordship. From the date of production, today is 74 days behind the bar, lordship.
This is similar to the bail application 3061.
Yes, lordship.
Same FIR, Bongaigaon.
Same affair, lordship. Same affair.
When was he last examined, Mr. Kaushik?
My lord, CD is he was last examined on 27/8, my lord.
27/8.
8.
Witnesses recorded.
Witnesses recorded, my lord.
No adverse antecedent.
adverse antecedent is not mentioned here, my lord.
All right.
The only thing is that his role is different, my lord. He is the main culprit, my lord.
Uh, what is his name?
Prasenjit Banerjee, Lordship.
Banerjee. All right. Please take down. Heard, Mr.
D Das, Lordship. D2 Das.
B.
D.
D. Das, learned counsel appearing for the petitioner. Stop. Also heard Mr. Mr. R.R. Kaushik, learned APP, Assam, appearing for the state respondent. Stop. This is an application under 483 of the DNSS 2023 for granting bail to the petitioner, I. Prasenjit Banerjee, who was arrested on 25/8/2024 in connection with Bongaigaon Police Station case number 290 of 2024, registered under section 61(2)(a) 1092, 1182, 1172, 3313 of BNSS 2023, read with section 25(1)(a) 2735 of the Arms Act. The case of the prosecution is that on 25/8/2024, the informant lodged an FIR alleging inter alia that on 24/8/2024 at about 11 p.m., the accused persons named in the FIR entered into the boundary of the informant's house with firearms and opened blank fire. It is the further allegation of the informant that thereafter, when the father of the informant came out, a Scorpio vehicle came towards him in high speed in order to kill him. It is also alleged in the FIR that the petitioner was apprehended with pistol and was handed over to the police. However, other accused persons had fled away. Accordingly, the FIR was arrested. Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner, being present on the spot of the occurrence, was arrested on the basis of suspicion and that the petitioner is totally innocent. Correct?
Lordship.
Per contra, Mr. R.R. Kaushik, learned APP, submits that the case diary reveals that upon an altercation between the petitioner and the informant, petitioner called his friends, including the don't write including, over telephone, and accordingly the petitioner and accordingly other co-accused had also come to the place of occurrence. Stop. Correct, Mr. Kaushik?
My lord.
Heard the learned counsels for the parties and also perused the materials on record, including case diary. Stop. It appears that the petitioner has been languishing in jail since last
75 days from the date of arrest, Lordship.
5 days from the date of arrest, i.e. 25/8/2024. Stop. It further appears that he was last examined on 27/8/2024. It further appears that the investigation has progressed substantially and the statements of the accused petitioner along with the co-accused and the other witnesses have already been recorded by the investigating officer. Stop. It further appears that there are no adverse antecedent against the petitioner has been collected by the investigating officer during the course of investigation. Stop. In view of the above, this court is of the considered view that further detention of the petitioner is not justified for the ongoing investigation. Accordingly, the petitioner is granted bail. Next paragraph. Resultantly, it is provided that the petitioner named above shall be released on bail in connection with the above noted case on furnishing bail bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate,
Bongaigaon,
subject of course to the following conditions. 1, 2, 3. With the above observations, the bail application stands allowed and disposed of. Send back the case diary.
I'm
Disposed.
okay. I'm okay.
For bail hearing, item number
Chair.
2.
That is-
May it please your lordship. May
Yes,
it please your lordship. My lord, here, my lord, my lordship has gone through the FIR, my lord. I am the accused number 2. There is no specific allegation.
this is the same FIR.
Same, but no specific allegation against me.
Just give me that. This is the same Bongaigaon FIR, Mr. Abdullah.
Lordship, same case.
Who are you?
I am the accused number 2, Aditya Singha.
You are not named in the FIR.
I am named in the FIR, but my lord, there is no specific allegation against me.
All right. Then Mr. Kaushik,
My lord, this is an anticipatory bail, my lord. Otherwise, he was also present there, my lord.
Only presence was there.
His
please,
presence was
on the
there.
basis of the presence, perhaps a suspicion has come. So,
My lord, not suspicion, my lord, because they came together, my lord.
do you have the case diary?
Yes, my lord.
All right, I'm granting him interim. I'm granting pre-arrest bail.
My lord.
So when the petitioner called, according to the CD, this petitioner is one of the petitioner who had come after being called, correct?
My lord, he because after because the other accused person came in a vehicle, my lord, and this petitioner and another accused petitioner, my lord, they were present at that place of occurrence from before, my lord, because they were discussing
all
about assaulting, my lord.
Now, this is item number 2. Heard Mr. SM Abdullah P. Stop. Also heard Mr. RR Kaushik, cleared APP for the state respondent. Chese, P. You can take it from this order only because the same thing, except 483, here it will be
482.
482. Okay. So I'm putting it in pencil, 482. And here it is who was arrested. In this order, it is mentioned as who was arrested. Here you say who is apprehending arrest in connection with ... The rest remains same. Got it? You see it from here, huh? The petitioner along with another co-accused was already present, Mr. Kaushik.
Yes, my lord. They also assaulted me.
This part you type it out, it'll be better. Heard the learned counsel for the parties and also peruse the materials on record, including case diary. It appears that petitioner was present in the place of occurrence when the incident had occurred. And case diary reveals that the petitioner had also participated in the altercation.
Altercation, my lord, yes.
It further appears that the investigation has progressed substantially and his statements of the co-accused and the witnesses have already been recorded by the investigating officer. It further appears that there are no adverse antecedent against the petitioner collected by the investigating officer during the course of investigation. Considering the facts and circumstances of the case, this court is of the considered view that custodial interrogation may not be necessary for the ongoing investigation. Accordingly, it is provided that in the event of arrest, the petitioner named above shall be released on pre-arrest bail in connection with above noted case on furnishing bail bond of rupees 25,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. 1, that the petitioner shall appear before the investigating officer within 10 days, failing which on and from the 11th day, the pre-arrest bail order shall have no force. That petitioner shall not directly or indirectly make any inducement, threat, or promise to any persons acquainted with the facts of the case, so as to dissuade them from disclosing such facts to the court or to any police officer. 3, that the petitioner shall refrain from committing any similar offences in future of which he is accused or suspected of commission. With the above observation and direction, the anticipatory bail application stands disposed.
Obliged, Your Lordship. Obliged.
Item 3 also arising out of the same FIR.
Yes, my lord, and he is also similarly situated with petitioner number 2, item number 2.
Where is N. Dubey?
My lord,
Where is the advocate for the petitioner?
my lord, perhaps he is not present.
So this is similar to item number 2.
Yes, my lord.
So same order then.
Yes, my
Item number 3.
yes.
May I please, Your Lordship?
You are appearing in item 3.
Item 3 appears. Yes, my lord, my she is
All right,
appearing.
I'm allowing it. The
My
same
lord.
then Mr. Quashing.
My lord.
This would be same as of 2, okay? And what about 4?
Item 4, the petitioner is already under interim, but
Same FIR.
same FIR. And but his role is different, my lord. He and the petitioner of item number 1 actually the main culprit, my lord. And the gun is also owned by this person.
Like Mr. Kaushik, in item 4, it appears he's already on interim, right?
Interim, but his statement is not in the CD, my lord.
Then you have his statement.
Yes, my lord.
As per my information, my lord, he has already appeared before the IO and his statement has been taken, my lord.
Yes, that is your information, but the
Oh,
APP
shit.
does not have that. So let the APP have the latest information.
Yes, my lord.
My lord.
Wait, no, sorry. Let up-to-date status be produced before, be placed before this court on Monday.
My lord, because CD is here, I have to return the CD, my lord.
And when do you want it? Wednesday? Wednesday.
My lord, this is from Bongaigaon, a little later, my lord, on 21st.
All right, on
It
20.
should be, Lordship, may be on 18th, 19, my lord.
You're already on interim
Lordship, that is there, my lord.
21.
My lord.
Lordship.
So 1, 2, 3 disposed of. This is
Interim to continue, my lord, until the next.
all right. Interim, if any, shall continue till the next date of listing.
I'm deeply obliged, my lord.
Obligement.
Yes. Kohima bench mentioning any?
Lordship. May I please, my lord?
Yeah.
Lordship, item number 7, Lordship.
Yes.
Lordship, I have.
Foxo. Foxo.
Yes.
Informant has been served. Informant served or not served? Mr. Counsel, please verify. If it is not served, then I'll pass that order issuing notice to the informant. You please, Mr. Counsel. Mr. Counsel, let us go ahead with the mentioning. You have a look with the file and then at the end of the mentioning, you let me know. Yes.
May I please, Your Lordship?
May I mention item number 9?
Yes, please.
I'm appearing on behalf of Taka Kichuk with a prior consent from the other side, your lordship.
You are for the petitioner?
Yes, my lord.
Yes.
I'm appearing on behalf of Taka
You
Kichuk.
want accommodation
Right, your lordship.
Uh,
2 weeks time, my lord.
as prayed for by Mr.
J. Newman,
J.
Newman.
Newman, learned counsel for the petitioner with consent from the respondent, list this matter after 2 weeks on a date to be fixed by the registry. Yes,
Much obliged.
Chise, you complete the mentioning.
May I please, your lordship, I beg to mention item number 2. Kindly allow this matter to be listed on Tuesday, that is on 12th next week.
Next week.
Yes, lordship.
As prayed for by MS
K. Lilisu.
so and so, learned counsel for the
For
petitioner,
petitioner.
list this matter again on Tuesday, so and so.
Much obliged. May I please, your lordship, I beg to mention hearing item number 8. Appearing on
Yes.
behalf of N. Kumar. Kindly list this matter after a week.
Have you taken consent from the petitioner?
Yes, your lordship.
Any objection? As prayed for by MS so and so, learned counsel for the respondent, list the, with consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry. Yes. Yes, Mr. Devnath,
May I please the lordship? Lordship, I beg to mention hearing item number 12 and 13, lordship.
you had circulated an adjournment
Lordship,
slip.
lordship.
Yes. As prayed for by Mr. V. Devnath, with advance adjournment slip, with comma, list this matter after
Lordship, can it be on next week,
date,
next Thursday?
list on such and such date.
Lordship, highly,
12 and 13, they are both together,
lordship.
same,
No,
12 and
it is not analogous, separate matter.
but same
Yes, yes,
prayer
yes,
for
yes.
both, isn't
Yes,
it?
Yes, yes, your lord.
13 also you want on Thursday?
Yes, yes.
All right. 12 and 13,
Obliged.
yes.
May I please, your lordship? Lordship, I beg to mention item number 11 on
Yes.
behalf of my seniors and the younger lordship. Lordship,
As prayed for by Mr.
Nogla M. Konyak,
So and so, learned counsel on behalf of Mr. Sentianger, learned counsel for the petitioner, list this matter
after 3 weeks, your lordship.
after 3 weeks on a date to be fixed by the registry. Yes, next.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 10, Lordship. This matter can come out after 2 weeks, Lordship. No
You-
objection.
You are for the petitioner?
Yes, Lordship.
As prayed for by MS,
S. Chang.
so and so, learned counsel for the respondent with consent from the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
Obliged, Lordship.
For motion, item number 1.
May I please, lordship.
Coming up for the first day. This is for the, this has come today for the first day, isn't it?
Yes, my lord, but then it has been charged sheeted. I have annexed the same.
Charge sheeted?
Yes, my lord.
Yes,
Lordship, there's no change of circumstances, lordship.
no, if he has been charge sheeted, let him appear before the trial court, before the committal court,
Yes, lordship. Yes, lord.
right? You appear there and your prayer for bail will be considered.
My
by
lord,
the-
after my bill has been rejected after it has been charged sheeted.
Correct, but at the time it was rejected, that time the charge sheet was not filed, correct?
It was filed.
It was filed?
Yes, my lord. That's why I have filed this.
You have the CD?
No, lordship.
My lord, but then I have annexed the entire charge sheet in this
Say that
petition.
you, will issue notice to the,
Lordship, lordship.
so now scan copy
Yes,
of
yes,
else, what is required to be given? The case diary, because it's already charged sheeted, it must have been sent to the court.
yes, lordship.
My lord, the entire charge sheet I have annexed in this petition.
Have you are the PP?
Yes, lordship.
Yes, what do you say?
Lordship, is a kidnapping case. They themselves have compromised. So, Prima facie, there's a clear case against,
No, but I'm
The
not
case.
convicting him.
yes, cross lordship.
Where is the charge sheet?
Yes. My lord, charge is at page 27, annex 0F. It starts from 27, page 27,
Page?
27. Relevant part starts from page 31.
Page
31, relevant portion.
kidnapping of a boy.
Yes, my lord.
The boy is recovered or not?
Yes. My lord, in this case, the compromise has been,
Where is the compromise?
yes, that is at Annexure E, page 25, my lord. Page 25.
Compromise is between whom?
The complainant, the alleged victim, and the accused persons.
A victim also.
Victim. Complainant is different, the victim is different.
What is the name of the victim?
Mr. Salman.
Where is the FIR?
My lord, FIR is at page 17, relevant part. 17.
They are relatives.
Yes. My lord, in this case, they are three accused. The
Uh-huh.
accused, in this case, they are three accused person. Accused number 3 and then the alleged victim, they are relatives.
Where is the FIR?
It is at page 17.
Lima. Page 17.
Yes.
All right. Yes, take down. Heard, Mr.
Vinokachum.
Vinoka Achumi, learned counsel for the petitioner. Stop. Also heard, Mr.
Kiangami, lordship.
K. Angami, learned PP for the state. This is an application under section 483 of the BNSS 2023 for granting regular bail to the accused persons, i.e. 1, 2, 3. Likhi diba naam Geeta, who were arrested on 13/8/2024 in connection with Newland PS case number 24 of 2024, registered under section 142/3 within bracket 5 BNS. The case of the prosecution is that on 13/8/2024, a FIR was lodged by one Shri Ahoke Chisi, chairman of Lotovi Village Council, before the officer in charge of Newland Police Station, alleging that one Mr. Salman has been kidnapped by 4 unknown miscreants who happen to come in a white Alto car and thereafter demanded a ransom of rupees 2 lakhs. Stop. Mr. Achumi, learned counsel for the petitioner, submits that the matter has been charge sheeted on 27/8/2024. Where is the charge sheet number?
That is at page 27, charge sheet number 11.
By charge sheet number 11 of 2024. Stop. He further submits that on the very day when the case was charge sheeted, a compromise was entered.
After 2 days.
It is the 24. No, the compromise is 24 and after 2 days, the charge sheet.
Yes, execution was done on 29/8.
Okay, sorry. Kibri likhila? He further submits that after 2 days of the charge sheet, a compromise was executed between the complainant I Ahoki Chise, the victim I Salman, and the 3 accused persons, including the petitioner. Stop. He further submits that the petitioner are innocent and due to misunderstanding, the present case has been lodged, which has now been compromised. Stop. Per contra, Mr. So-and-so Leonard PP submits that there are materials, any materials?
Yes, Lordship.
That there are materials available in the case diary incriminating the petitioner for the offense alleged.
Lordship.
Stop. Any antecedent, adverse antecedent?
That
No.
instruction I don't have yet. Lord.
No, my lord.
He, however, fairly submits that there is nothing adverse at this stage available against the antecedent of the petitioner in the case diary produced by the investigating officer.
Lordship, but I have not seen the.
You have not seen the case diary. Sorry. Case diary kothato bad di diba, huh? He has received no instructions as regards antecedent of the petitioner. Stop. I have heard the arguments, I heard and perused Didia. It appears that pursuant to the FIR lodged, the victim was recovered
Yes.
and upon conclusion of the investigation, a charge sheet was submitted on 27/8/2024, white charge sheet number 11 of 2024. So, how many days?
88 days.
Huh?
As of today, 88 days.
88.
Yes, my lord.
It further appears that pursuant to the submission of charge sheet, a compromise deed has been executed on 29/8/2024 between the informant, victim, and the accused persons, including the petitioner. Stop. It further appears that the investigation is completed and the petitioner has been languishing in jail since last 88 days.
Yes.
Stop. In view of the length of detention and the facts and circumstances of the case, this court is of the considered view that further detention of the petitioner is not justified. Accordingly, petitioner is granted bail. It is provided with the conditions allowed.
Obliged, my lord.
A bail bond of rupees 15,000,
That will be less, Lordship.
25,000 satisfaction,
District Session Judge.
district session judge,
Dimapur.
Dimapur. Disposed of.
I'll oblige, my lord.
For admission, item number 3.
Quashing.
Yes.
There is a compromise.
Yes, there is a compromise.
Anybody appearing for the, is there an informant?
Yes,
What
my
was
lord.
the- Huh?
The accused has compromised the victim as well as the complainants.
Who is appearing for the victim?
Lordship, I'm appearing for the victim.
Compromised?
Yes, your lordship.
So on the basis of the compromise, it can be quashed?
Yes, you know, the offenses involved are defamation.
Are of
500, 354C and 66E of the IT Act.
where is the FIR?
The FIR is page 23.
Page?
23.
The girl is a minor.
No, not a minor.
Where is the FIR? I'm not getting the FIR.
2, 3,
2?
3. The next year 2, page 23.
Posted. You are the accused is Malpura.
Yes.
Huh?
Lordship.
Posted explicit pictures.
Yes.
So they were in a relationship.
Yes, they were in a relationship since 2018.
Where is the compromise?
Page 18.
This petition is filed jointly or it
No,
was
not jointly. The respondents, they have also filed their separate affidavits.
what are these affidavit in opposition filed?
By the complainants as well as by the victim.
The complainant and the victim is different.
Yes,
Who is the complainant? Respondent numbers?
4, 5, 6, 7.
So this is complainant. And there is an affidavit of the victim.
Yes, respondent number 2.
Victim is 2.
Yes.
All right. Part of. Heard Mr.
L. Iralu.
L. Iralu, learned counsel for the petitioner. Stopped. Also heard
Yes, Sophie, madam.
Mr.
A. Sophie.
A. Sophie,
Yes, my lord.
learned counsel for respondent number
4, 5, 6, and 7.
4, 5, 6, and 7 within bracket complainant. MS. So and so learned counsel for respondent number 2 within bracket victim, and Mr. So and so learned PP for the state of Nagaland. Given appearance slip. By way of this petition, under section 482 of the CRPC, the petitioner is seeking quashing of the criminal proceedings in GR case number 50 of 2023, pending before the learned judicial magistrate first class, Nagaland, arising out of Chozuba PS case number 11 of 23 under section 354C/500 IPC, read with section 66 capital EIT Act, on the basis of compromise/settlement arrived at between the alleged accused petitioner and the victim and complainants. Stop. The case of the prosecution as transpired from the FIR is that the accused petitioner and the victim were in a relationship, and pursuant to their relationship having been broken, comma, after several years, broken, the accused petitioner posted explicit pictures containing nudity of the victim without her consent using her stolen FB account account on 3/9/2023. Stop. FIR FIR dated, where is the date?
11/9.
11/9/2023. Stop. Pursuant to the registration of the FIR, it appears that a compromise was entered between the victim and the accused person, wherein they have amicably settled the matter amongst themselves. And pursuant to such amicable settlement, the victim has agreed not to pursue the criminal complaint lodged against the alleged accused. Stop. It further appears that pursuant to the aforesaid compromise, in addition to the aforesaid compromise, comma, both the victim as well as the complainant has filed affidavit in opposition in the present criminal proceedings, wherein they have categorically averred that they have no objection if the criminal proceedings are quashed. Stop. Mr. So-and-so learned counsel for the complainant as well as MS so-and-so learned counsel appearing for the victim also concedes to the same in the court. Stop. Paragraph clauses 1, 2, 3. Clauses. The deed of compromise is reproduced. Deed of compromise dated 19 June 2024 is reproduced here under for ready reference. Quote unquote. Page 18, A to A. And the affidavit of the victim, which is the paragraph.
There'll be there of 6, yes, 5.
Paragraph 4, 5, and 6 of the affidavit in opposition filed by the victim stroke respondent number 2 is also reproduced here under for ready reference. B to B. Pink flag at affidavit victim stop. In view of the aforesaid endorsement made by the learned counsels appearing for the complainant and victim, and perusal of the compromise deed as reproduced herein above, as well as the averments made in the affidavit in opposition filed by both the complainant and the victim, comma, further continuation of the criminal proceeding against the accused petitioner in the facts and circumstances of the case shall not be justified. Accordingly, for the ends of justice. The criminal proceeding in GR case number 50 of 23 pending before the learned JMFC FIG and the connected FIR in Sosoba PS case number 11 of 23 stands quashed. With the above observation direction, the criminal quashing petition stands allowed and disposed of. The prayer plus Hainuba.
My lord, for respondent, for item number 7.
One second. Disposed of. Yes. Yes, we will reach 7. Wait for some time. Wait for some time. There is only 3 matters in between. Yes.
For admission, item number 4.
Some repairing works.
Yes, your lordship.
Yes. What is the status now?
My lord, actually, I'm having one building and it is under litigation, your lordship. Since 2016, I constructed, half constructed building is there. Then your lordship, I have been served with a notice by local GB that your gate, it may dilapidated condition, it may collapse at any point of time and cause accident. And your pit is also not covered, so it is a breeding house of the mosquito. So you do this immediately. Then since there was a status quo order from the Deputy Commissioner Dimapur.
Some verification report.
Yes. Yes.
Lordship, we have filed.
You have filed.
Lordship.
So why is this matter there for today? What is to be done today?
To pass the order whether.
In the IA.
Yes, your lordship.
The IA is listed. Today.
Yes.
What is the prayer in the IA?
I had to allow me to repair this dilapidated gate and to cover the pit.
Where is the status quo order?
Status quo order is, your lordship. It will be in the main suite, your lordship.
Any objection to the prayer?
No, lordship.
No, Lord. No. Where is the status quo order?
Status quo order, it will be in the main suite. Yes. 2017, your lordship. The order was passed by the Deputy Commissioner, Dimapur.
So again, that order was challenged by you in the WPC.
Yes, your lordship.
Correct.
Earlier, there are several rounds of litigation, your lordship.
Yes, but
and it is the 3rd round of litigation before this honorable court. Actually, your lordship.
But you, where is the report? Verification report?
Lordship, I filed it yesterday.
Oh, you have filed it yesterday. It has not come
Yesterday.
on record, I think.
I have served the copy to the.
Affidavit in opposition. No, it has not
affidavit.
come.
Affidavit of-
It has come, Lima. The verification report. It is not here. You filed it yesterday.
Yesterday, Lordship.
And your lordship, matter is very urgent because if it fall down and if there is any
All
accident.
right, I'll take it, just have a look at it. Otherwise, Lima, call for the report. I'll take it at the end of the list, huh?
My lord.
Call for the report. Yes, Mrs. Joshua, appointment of
For orders.
arbitrator.
Yes, your lordship.
Yes.
My lord, by the office note dated 26/9/2024, notice is, according to the record, notice is already served to the union respondent, your lordship.
It says return service report awaited.
My lord, may I take your lordship to kindly, the order dated 1/10/2024. 1/10/2024. In fact, notice is complete, but we were asked to send another notice. 1/10/2024, my lord, order dated.
Yes. Shall
May-
take fresh steps.
May I take your lordship to the second page, second paragraph. Office note dated 26/9/2024 states that the tracking report of notice
I've read it.
Yes.
It says item delivered, but since there was no representation, there's a
On behalf of-
judicial order
Yes,
from
your
fresh
lord.
steps.
Yes, your lord.
Correct. Now, fresh
lord.
steps has been done or not? Because
It's already done, my lord.
But the office note
My lord.
611 says that fresh notice issued, but service report awaited.
My lord, since this is an arbitration petition, it has been
Mr.
pending.
Joshua,
Yes, my
There
lord.
is a judicial order.
My lord. I got your lordship.
Correct.
In fact, we have, sir, yes, your lord.
I am for respondent number 2, your lordship.
Who is R1?
R1 is the Ministry of Road Transport and Highways, your lordship. My lord,
Hence,
yes, your
otherwise
lordship.
I would have proceeded. Why should the
My lord.
arbitrator application be pending for so long?
Yes, my lord, your lordship.
It doesn't serve the object with
My
which the arbitration are provided, isn't it? These
My
are
lordship.
matters which has to be expeditiously done.
Lordship.
But then there is a judicial order.
We've taken the steps on 410 again, my lord.
Yes, but then services awaited.
Yes, your lordship.
So you wait for some time and after that it can be deemed if the territory period is
My
gone.
lord.
Await service in respect of respondent number 1. List after
1 week, my lord, perhaps
list
by
after
then.
1 week on a date to be fixed by the registry.
Oblige, your lordship.
For hearing, item number 6.
May it please your lordship.
Yes.
My lord, this appeal arises out of a very small order. A suit was filed by the predecessor of the appellant. In the suit, certain reliefs were sought. The respondents filed an application under Order 6 or Order 7, Rule 11, seeking rejection of plaint. The rejection of plaint was sought primarily on the, rather, that was the
You
loan.
are against the order passed in
Yes.
rejecting or not
Rejecting.
Rejecting. You are against the rejection order.
I am against the rejection order.
What was the ground of rejection?
That is somewhat cryptic, my lord. I'll read it out to your lordship.
You are the plaintiff.
I was the plaintiff. The basic ground urged by the defendants was that the suit was barred because of section 154(1)(c) of the Assam Land Revenue Regulation. And therefore, since there is a barring provision of 154(1)(c), so therefore the suit should not be heard. Rather, the plaint should be rejected. That was the ground.
The bar was in the
Assam Land Revenue Regulation. They said that the relief would be barred under 154(1)(c).
regulation 1.
Regulation 154(1)(c).
1C.
Yes.
All right.
Now, in the reply that I had filed, rather my predecessor had filed, I also took shelter of 2 decisions of this honorable court. Long time back, my lord, it was said that 154 does not bar a civil suit. Civil court's jurisdiction is not obstructed. The learned trial court does not give any finding on.
Can I get the Assam Land Regulation and CPC? Assam Land Revenue Regulation and CPC. Yes, yes.
The learned trial court does not give any finding on it, whether the suit should be treated as barred under 154(1)(c).
Okay, there is no finding to that effect.
No finding to that, but learned trial court takes a turn to contend that the suit is barred under res judicata.
Res judicata.
Yes.
All right.
Now, the basic contentions that I am going to urge before your lordship are like this.
So the issue that is involved is whether, first of all, there is a bar
Yes.
under the Assam Land Revenue Regulation.
And secondly,
if anything prior to filing, if anything else was filed in the same subject matter. These are the 2 questions.
These are the 2
Which is
questions.
involved in this appeal.
Yes, absolutely. Now, the contentions that I would like to urge before your lordship that are like this. Order 7, Rule 11 enumerates the circumstances on which a plaint can be rejected. Now, res judicata is not one of those circumstances.
No cause of action.
Yes, no cause of action, but or suit is barred under any particular provision of law, or
That, of course, they had taken that ground, but according to you, the trial court didn't go into that.
yes,
And went into the fact that it is barred by res judicata.
res judicata, sort of. That
And
is also not a
Now
very
you're
clear.
trying to argue that res judicata is not one of the ground enumerated for rejection under the
Exactly.
Order 11, correct?
Exactly. Because of the fact that order res judicata, it has been held by in umpteen number of decisions that it involves a mixed question of law and fact.
Law and fact.
And that cannot be gone into in
At
Order
the
7, Rule 11.
preliminary
Because,
stage.
yes, because it will require an adjudication.
Evidence.
It will require an evidence. Now, why these had happened? Therefore, my lord, I'll also like to give a preface to the occurrence of this suit. There, I have been in my predecessors. My predecessors had been in possession of a certain plot of land in the Dimapur town.
Yes.
Now, one fine morning, it is discovered that there is a masjid committee nearby, which happened to raise a claim that the suit land belongs to them. And in fact, there was a revenue record correction done by the revenue authorities, mutating the name of the masjid committee in respect of that particular land. I'm just giving a brief introduction, Lordship. Now, when I happen to notice that change.
Just one second, Mr. Dutta, you will take some time, right? Just, because there was one matter, item 7. Yes. Did you all check? Informant,
The informant is respondent number 2.
already notice has been served?
It has been the registry service.
Oh,
Okay.
Lordship, as per the orders I perused, there, I browsed through, it appears notice has not been served to the,
Just one sec, Mr. Doctor. Then I think their item is the last item, correct? I can free the councils. Notice is not served, I think. Notice is not even given, I think.
it appears it's not given, Lordship.
No? Who is respondent number 2?
The informant,
The informant. And what is the relation of the informant with the victim?
the mother.
Mother. Right. It appears that the respondent number 2, who is the informant stroke mother of the victim, though is impleaded in the present criminal appeal arising out of an offense under the POCSO Act, comma, notice has not yet been issued to the said informant. Stop. In view of the decision of the division bench of this court in the case of Deepak so-and-so in criminal appeal so-and-so, comma, notice it is mandatory to issue notice to the parents stroke guardian stroke support person of the victim in offenses arising under the POCSO Act. Stop. In view of the above, let notice be issued to respondent number 2 through the jurisdictional police station. Stop. Let a copy of the criminal appeal along with the paper book be served to the office of the public prosecutor of the state in order to enable the office of the public prosecutor forward the same to the jurisdictional police station so as to serve the same upon the respondent number 2. Stop. Let the officers of the jurisdictional police station submit a report of service thereof to the office of the PP. Stop. The notice shall contain, shall contain this so and so. The same thing. List after 3 weeks on a date to be fixed by the registry. Yes, Mr. Datta.
So therefore, my lord, as I was submitting, there is a plot of land over which, my lord,
Yes, please.
there is a plot of land in the Dimapur town over which I am having occupation, in fact, from the days of my predecessor in interest. And one fine morning, it is discovered that the masjid committee who situates just on the adjacent plot of land, they happen to have undertaken a exercise so as to correct the revenue records, and the revenue records, the effect of the correction is that in respect of the particular plot of land.
The Masjid committee had initiated correction of the record of rights.
Yes, and the record of rights were corrected and the patta were named after them. So I file
the Masjid committee.
A Masjid committee. So I file an application before the revenue authorities saying that this has been done of very many reasons, one being that without hearing me, and therefore it should be corrected and it should be rectified to the original position. That was refused by the revenue department authorities. and I file a suit. That suit was filed in the year 2009.
2009.
Then in that 2009 suit, again an application for Order 7 Rule 11 was filed, and the trial court allowed this application, resulting into rejection of the plaint that I had filed. Subsequently, this plaint was filed.
This is, what is the suit number?
Earlier
What is the earlier number?
number was CS1 of 2009.
CS1 of
2009.
2009.
Yes.
And that rejection order is
That rejection order is at page 113.
Page 113. Can I have the date?
Yes,
Just give me the date.
yes,
22/12/09.
22/12/09.
yes.
Okay. And the present CS?
Present one was registered as TS,
TS,
title
and-
suit. This is registered as title suit 1 of 2010.
The red judicator is because they are connecting it to the 2009.
Yes.
That is how the red judicator
Yes,
concept is
yes,
coming.
yes.
Title.
Although, my lord, it will not be within the ambit of the Order 7 Rule 11, but just to put the facts in order, my lord, I am highlighting that. That order, that CS1 of 2009, the plaint is at page 104.
Page 104.
Yes, that is the plaint of.
Mr. Adda, since I'm taking this for, I'm assuming I'm taking it for.
Yes,
final
yes, yes,
disposal,
yes, my lord,
so
otherwise.
I would appreciate after the conclusion of hearing a small
Yes, yes.
gist of the,
Yes.
you know.
Yes. Well, I'll try to be as brief as possible because the ambit of the, appeal is although the brief has become
Yes,
voluminous.
but it is that small issue.
Yes, it's that small issue.
We'll have to finally go to that impugned order and see
Yes.
whether that would have been done under Order 7 Rule
Yes,
11, isn't
yes,
it? That
that's
is
it.
what you are arguing.
Yes, yes.
Subject to.
Subject to what my learned
the-
friend will argue.
Mr. Your name?
P.B. Paul.
Paul. Mr. Paul will say.
Yes. So therefore, my lord, that was a suit.
Just one second. Chelsea, I don't want you here now. You type your orders. When I want you on, we will call you. Okay, complete those. Yes.
So that suit CS1 of 2009 was dismissed. We did not carry any appeal against that. Instead, we filed a fresh suit. That is TS1 of 2010, of which the plaint your lordship will find at page 28.
Page 28.
8. Now, in this suit, my lord, the defendants again come and they again file an application under Order 7 Rule 11.
That is their page.
This Order 7 Rule 11 application, your lordship will find at page this is at page 227. 227.
7. And the
Yes.
earlier Order 7 Rule 11 is there.
Earlier Order 7 Rule 11 application is also there, my lord, and I'll just get the page number and submit it to
No
your
problem.
lordship. Now, this application, in this application, my lord, if your lordship will kindly come to page 227,
Yes.
this is the application filed by them, and the principal contention. I'm sorry, my lord, I have given a wrong page, my lord. This is not 223. 223 is my reply. Their application will be at
227.
no 227 is in fact my reply. Their application is at 208.
208.
8. If your lordship will kindly come to 208.
208. Yes.
Yes. Your lordship will kindly note the heading in the matter of first heading.
Yes.
It was an application under Order 7 Rule 11D. Now, if I take your lordship to the Rule 11D of CPC, my lord.
CPC. Yes, D.
Yes, Rule 11D says, my lord, I'll read from the Rule 11
Barred by
itself.
any law.
Yes. The plaint shall be rejected in the following cases. A, B, C, D, E, F. There are 6
But
eventualities.
let's just read this ABCD one.
Yes. First, where it does not disclose a cause of action. Second, where the relief claimed is undervalued and the plaintiff, on being required by the court to so correct the valuation within a time to be fixed by the court, fails to do so. Where the relief claimed is properly valued, but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the
Alright.
court to
And then
supply.
D.
D. The suit appears from the statement in the plaint to be barred by any law. E is where it is not filed in duplicate. Well, these are procedures.
So
E and F
basically,
is,
cause of action, undervaluation, not properly stamped,
yes.
and if it's barred under any law.
Law.
And
If it is not filed-
filed in duplicate and
And
any
fails to comply with any of the
these are
point.
grounds
Yes,
for which a plaint can be rejected at the outset
At the
under
outset.
Order 711.
Rule 11. Now, your lordship will notice that the res judicata is conspicuous by its absence as a ground on which a plaint can be rejected at the threshold. Because res judicata will involve a question of fact as well as law. So this was the application filed by them. And kindly now your lordship will see what they had sought. If your lordship will kindly come to page 210.
Yes, D. So this is for barred.
Yes.
Yes,
Now, if your lordship will kindly come to 210, paragraph 3.
yes.
The petitioners state that on a plain reading of the facts contained in the plaint and the documents filed and impugned by him would clearly establish that the title suit of the respondent plaintiff is hit by the provisions of Order 7, Rule 11B and Section 151 CPC. 151, that is how it has been
But
framed. But basically,
what is the basis of the averment 3 that it is hit under 11D?
because there is a prayer in the plaint which relates to correction of revenue records.
That is barred according to them.
According to them, that is barred. Now, that correction of records, now they have explained in the grounds below how it is barred. If your lordship will kindly come to paragraph page 211.
Yes.
There they have stated that the Dimapur White order number so issued by the Deputy Commissioner Dimapur has been challenged by the plaintiff. Respondent plaintiff also reflected that the same order has been taken as one of the cause of actions for filing the title suit. Under the provisions of the Assam Land and Revenue Regulation 1886, hereafter shall be referred to as the Regulation 1886, certain types of disputes are exempted from the cognizance of civil code. The issue in regard to the validity or effect of any settlement cannot be questioned before the civil court under the provisions of the Regulations 1886. Since the order number so-and-so is purely a settlement order made in favor of the Jame Masjid Committee, and its validity has been questioned by the respondent plaintiff in civil court, the title suit of the respondent plaintiff is barred by Order 7, Rule 11D of the CPC, as well as by the provisions of the Regulation 1886. Now, the regulation of 1886 is 154. So this is their first challenge.
And there is a remedy available.
And there is a remedy available because if
in the regulation.
In the regulation, I can file an appeal before the appellate authority. Now, this was the prime contention before the court.
Let us go to the impugned order.
Now, impugned order, your lordship will find at page 2.
Unless you wanted to show something else.
No, I'll just take your lordship to because I'll also show your lordship the 154, how it has
Yes,
been.
I would like to go there, but let us see the impugned order one.
Now, if your lordship will kindly come to page 250, that is the impugned order.
Yes.
And the impugned order operates from page 200, starts from page 251.
Yes.
Now, the first paragraph, your lordship will kindly notice.
It became 11A.
Yes. Whereas
It was
the
11D.
Yes, it ought to have been 11D. But for the wrong quotation also.
But that is for cause of action.
Yes, the entire approach will be different.
Cause of action would mean that there is no.
There is no cause.
The
The
res
facts,
judicator is
No.
not about cause of action,
No,
is it?
no.
Correct me if I'm wrong.
no,
but
no, no.
That cannot.
Res judicata is not about cause of action. So why I am showing this particular paragraph, because if the court is to go to the bone of contention of the parties, the particular provision in the Order 7 Rule 11 will guide the course of action. Now, if you are taking 11A, then your course of action and
Will be
inquiry will be
different.
something else. If you are taking 11D, your course of action
Then
and
we should
inquiry.
just see if there is a bar.
Yes. Now, if you, I'll read out to your lordship, my lord, it's a not very lengthy order.
Yes, please.
The brief of the application arising out of this said title suit 1 of 2010 is that the respondent plaintiff filed the said title suit for declaration of right and title over a plot of land within the north side of Dag number so-and-so of the block number so-and-so of Dimapur town, relying on a permit dated 20/2/1963, purportedly issued by the Assistant Commissioner Dimapur, wherein it mentioned of Dimapur Bazaar. The respondent plaintiff averred the said permit is a grant under the Assam Assessment of Revenue Free Wasteland Grant Act 1948 and paying the Dao house tax. Thereby, the applicant prays for rejection of the plaint on disclosure. My lord, I am sorry to pause here. At times, my lord, the learned trial court has interposed the parties. Sometimes it is described as applicant, sometimes it is described as otherwise. The applicant prays for rejection of the plaint on the non-disclosure of cause of action. Now, here is the change in the approach. As the respondent, because the first application.
So where has the trial court recorded this?
Probably,
They have got rejection for non-disclosure of cause of action.
Probably, my lord, the first suit that was filed, CS9, there the application was filed that it does not disclose cause of action.
So it means that the trial court inadvertently had taken that.
Maybe. Maybe. Or otherwise, my lord, maybe because of the arguments, as it appears to me, lord, the arguments were quite lengthy from both the sides. Maybe the trial court misconstrued the facts. That can also be one of the reasons.
But otherwise also, just for academic discussion, Mr. Datta, suppose, because you see, nomenclature doesn't matter.
Yes.
If the power is there.
Yes.
Right?
Yes.
So in the event there is a situation that the plaint does not disclose cause of action and the application was filed under 11D, even in that situation, the trial court can always go ahead and reject it under 11A. Suppose that there is a case.
But
a case has to be made out.
Case has to be made out. But in that circumstance, if the trial court would like to proceed on 11A, I'll have to have an opportunity to defend my case. If I find that the other side had filed an application under 11D and I set up my defense in that fashion, and if the trial court now makes a shift, then naturally it is a deprivation of my right. If I am to understand that, no, this is also their contention that it has to be dismissed on the ground of cause of action. Accordingly, I'll have to satisfy the court that, look, this is the facts. These are the facts out of which the cause of action arises. So therefore, my lord, to that extent,
opportunity you didn't get.
To that extent, my lord, it will be in excess of the jurisdiction.
Let's go ahead.
Now, the cause of action, as the respondent plaintiff has neither pleaded the material facts that the suit land in the instant case is pertaining to the purported grant under so-and-so, nor essential component to constitute the facts to prove the case, such as entry of an estate in the Deputy Commissioner's Register of Revenue Free Estates as a separate grant, the issue of an assessment roll, that is Jamabandi, the record of the rates assessed on such estates, finally, validity of a settlement granted by the competent authority and the formation of entries in the record of rights in consequence of such settlement cannot be challenged before the civil court under section 154(1)(a) and (c) of Regulation 86. Considering the submission of the respondent plaintiff to reject the application on the ground of under the rules of administration of justice and police in Nagaland so-and-so, there is no, that was a defense taken that since there is no separation of judiciary and executive, the erstwhile rule will apply. I am not going into that. There is no scope of under 7 Rule 11D of the Code of Civil Procedure at it as it envisages framing of issues of facts and law and to decide the case. It is true that the Code of Civil Procedure is applicable in the spirit only, not in letters in the state of Nagaland, where it means where the procedures are lacking in the rules of administration of justice and police. The Civil Procedure Code applies as a guide to resolve or adjudicate the dispute, although strict procedures may not be enforced. Therefore, rejection of the application on the ground of application of the Code of Civil Procedure cannot be sustained or overlooked, as it is a public policy to avoid unnecessary litigation. Besides, the applicant's defendant's counsel rightly pointed out that the trial court can exercise the power under Order 7 Rule 11 at any stage of the suit before registering the plaint or after issuing of summons to the defendant at any time before the conclusion of the trial. And for the said purpose, the averments in the plaint are German, and the pleas taken by the defendant in the written statement would be wholly irrelevant at that stage, was relied on whether some construction error in construction law, relied on the Supreme Court of India decisions so held in so and so, so and so. Therefore, the respondent plaintiff contention has no merit and the instant application is sustained. Secondly, the respondent plaintiff's contention of none of the pro forma defendants had appeared despite of summonses served and objected to accept the prayer of the applicant defendants in their absence cannot be sustained. The status of the pro forma respondent is to assist the court during trial, and therefore, when the plaint can be rejected at its initial stage, the pro forma defendant's appearance should not hinder to dispose of the application. Thirdly, respondent plaintiff further raised the present applicant's defendants has no locus standi. Well, that's why I had shown your lordship the application that they had filed. The question of locus standi is also not one of the contentions in Order 7 Rule 11. Locus standi to file the present application as Mutawali only has the locus standi under the Works Act. The applicant's defendants are included as defendants in the title suit by the respondent plaintiff, not the Mutawalis under so and so. So when the respondent plaintiff has not included the necessary party as per the law, applicant's defendant's name has to strike out, and at the same time, plaintiff's plaint cannot keep alive with implement of necessary party if there is any disclosure of cause of action.
Just one sec, Mr. Datta. Mr. Paul, in the application that you had filed in TS 1 of 10,
Yes.
have you taken these grounds about non-disclosure of cause of action, number 1, number 2 about locus standi? Admittedly, you have not taken.
I have not taken, your lordship.
If you have not taken those grounds, you cannot plead those grounds. Have you even argued those grounds before the court?
Yes, your
You have
lordship.
argued.
And
But how can you argue
I-
without
I-
taking these grounds?
Your lordship, while this TS 1/10 was placed, that time you come to know that CS 1/09 was on the same matter in issue, same party.
That is all right.
Yes.
But you see, are you appreciating the argument that is coming from the learned senior counsel? Because he is trying to project a case that the learned trial court is perhaps taken the first application filed by you in CS 1 of 9.
Yes.
Because those are these grounds which is now being dealt and considered by the impugned order were available in that application, but not in the second application.
Yes.
Now, if those grounds are not there, how can the trial court go into all this? In that event, they will not be getting opportunity, because admittedly what is on record and what can be seen is that your application is under 11D.
11,
Correct.
11, yes.
Correct? But,
Order 7
but
11.
the trial court is proceeding on the basis of 11A.
Yeah. Previous suit, when the previous suit was taken, your lordship.
That is different.
Now, your lordship, whether
No, because
one should
why I'm
approach the-
asking this is
Your
that
lordship.
if that is the thing, then perhaps this has to go back.
Exactly.
This cannot stand. How can the trial court go into 11A when 11A is not what you had contended? You had
Not
contended
even
in the-
pleaded.
your pleaded case.
Your lordship,
Because you see, it is apparent that both the course of action is different. One has to, you see, you will also not quarrel on that, because when you are placing your arguments on D, all that you have to show is whether it is barred, not barred. Correct? You will show that it many things will come. They have to show a lot many things in their pleadings, in their objections that they are filing, that yes, the case in hand does disclose a cause of action. They have to, in support, they have to make those averments. Now, they didn't get the chance because your case was under 11D. It was not under 11A.
Now, your lordship, this molding the relief.
So
there is
why
also-
I am interacting with you both is that I'm trying to give you what is in my mind.
Yes.
Because otherwise, instead of going for lengthy arguments, one way is to
Cut short.
Yes.
cut short and remand it back to consider fresh your application, and you want to add something, you bring it in accordance with law
Your lordship,
by giving them an opportunity.
but your lordship, this is the third petition, your lordship.
Could be.
My learned friend has escaped one petition, that review petition. While this CS 109 was disposed, then they have filed one review petition.
Mr. Counsel,
Then review petition also disposed.
I'm not on CS 1 of 9 because the impugn order, which is in front of me, is the order passed in case of TS 1 of 10.
Yes.
Correct?
Yes.
And in TS 1 of 10, you had filed an application under Order 7, Rule 11D. Against that application, this impugn order has been passed.
And
Correct?
this is under challenge.
This is the admitted facts.
Yes, your
Now,
lordship.
when you read this order appears to have been passed under 11A. Whose case is under 11A? Your case on record is under 11D. Correct or not
Yes, sir.
correct? Then what remains? At the very outset, the order appears to be, because it is an order passed under 11A,
Yeah.
whose case is non-disclosure of cause of action?
That is nobody's case.
A ghost case. Yes or no? You see, that is why I'm saying I don't want, if you both agree, I shall not go into the merit. Instead, I can remand it back for a fresh consideration.
Then yes.
That could be
That
one
can be
course.
done.
But yes, that is one course, my
Yes.
lord, I am agreeable to it. But I have also a rider. The rider is to the extent that if your lordship even takes into, as an appellate court, my lord, because the powers are coextensive, even if your lordship will take into account his application, so to say that this is barred by 154. Well, in 1991 judgment, this honorable court decided that 154 does not bar jurisdiction of civil
In
court.
this case, has this been considered or not?
No, not at, no.
See, that is why I'm saying of remanding. Had the court below considered that argument, I could have also looked
Yes.
into the correctness of that part. Since on the face of it, it looks there has been something wrong. Perhaps what Mr. Datta saying is correct. Maybe the other, by mistake, could be the other application which was.
And the aspect of res judicata has been gone into in the page number 255, whereas that is not even the pleaded case of the
250?
255.
So, read that.
255
Is the
towards the last, Miller, about 8th sentence from top. Therefore, on the face of record,
Therefore,
it will be
yes, I've got it.
9th sentence. Therefore, on the face of the record, there is no title document of the respondent plaintiff. In the present suit, there can be no title dispute with the cadastral area in Dimapur on the above facts, except where there is an express provision of law to which no such facts pleaded in the instant plaint. The civil court cannot interfere into the competence of revenue authorities in allotment of land unless there is a prima facie commission or omission of curtailing a person's right in view of the above provisions. Whatever title it may be issued without entry in revenue authority record, it must be treated as illegal. It is unfortunate to see that a permit purported to be a grant under the Assam so-and-so for more than 72 years has no record in the revenue authorities. Therefore,
These things were there in the pleadings.
that's why I said,
Yes.
Miller, perhaps this pleading in the CS1 of 2009.
I'm talking about TS 1 of 10.
No.
Where have you pleaded this in your application?
It is nowhere. It is nowhere, Miller.
But this is a first appeal.
First step.
First step.
And down below, your lordship will find the observation. Besides, this reveals that the respondent plaintiff had filed CS1 of 2009 on the same facts and issue and rejected by the trial court and thereby assailed for review by review case but failed. On the above facts, this court has no jurisdiction to entertain the suit as rightly pointed out by the so-and-so. Now, here, although not uttering the word as res judicata, he says that since yes, you had filed and that was rejected, so this application is allowed and your suit is rejected.
Now, since it's a first appeal, so let us see what are my powers.
Your lordship.
What can I do at this stage? Remand is one.
Yes.
Remand of case by appellate to the court. Remand the case, for the direct, what issues or issues, right?
Remand is certainly within your lordship's power.
That I know, 23 and 25, right?
Yes, yes.
24.
24.
See, because why I'm thinking of remand is in that way, the questions will be open. And maybe I can remand and I can,
nobody will be prejudiced.
And if you want to take up the issue of res judicata, you can take it up in accordance with law.
If it is permissible in
If
law.
it's that is why I said in accordance with law.
Yes.
Yes.
Whatever you can do, you do in accordance with law. But they should be given opportunity. Now, any decision on that point, that 11A, 11D, on the face of it, you are correct. The way you were going to deal with an application, obviously that recourse is going to be different.
Yes.
That is very apparent. But anything to in some.
But honorable court has taken
No,
decision on A.
my lord, possibly your lordship is asking me that in an application under 11B, whether it can be converted.
Correct.
My lord, of course, I don't have any decision, but that becomes very abhorrent to the scheme of the progression
No,
also.
anything in support of what you said, that both the recourses would be different, the approach. If an application is filed under A of 11 or under D of 11, both the approaches would be absolutely different.
No, that I am saying because the very premise on which
Understand that
Yes.
I understood, but anything beyond that,
no,
in case you have it.
on that I have no case law.
But that is very apparent.
Very apparent and very logical also.
Because
Lord.
under D, you have to show it is
Yes.
barred or not barred. Under A, you have to show whether discloses cause of action or not. So the way, if you take it under A, that is how they are going to file their objection. Now you have filed it under D, so they have filed it in that manner,
No.
showing that it is not barred.
And that is why, my lord, in my objection, I can show your lordship. In my objection, emphasis was that right from the 1991 judgment of this honorable court, I have shown that 154 does not bar.
Does not bar. You were on that.
I was on that.
But the trial court, the trial court has not even gone into that.
Not even gone into that.
No, I consider that one. There are
See,
many
that
category of
is what-
judgment here.
That is what I am saying.
Yes, yes.
Then I will remand it.
And the resultant order is, your lordship will find in the next page, whereby this 256, whereby as a result of the decision, 56.
Yes.
So as a result of decision in 255, the suit has been dismissed. Suit has been dismissed. Page 250, in view of
This
CMT.
is in TS.
Yes,
Yes,
yes.
yes, yes.
It is the main suit because
That was.
the learned court has not
case.
disposed the main suit in a.
This court will have to interfere with both these
Both,
two orders
both
and
the-
send it back
Yes.
to consider it fresh.
Then the matter will start again from preliminary objection,
From that,
preliminary.
No, the applications are already on the board.
No.
So, no.
No, I'm, that application, that from the preliminary,
correct.
we may be given chance to,
Do
the
whatever
11
is
11
available.
11B application and my objection is already there.
Correct, so
So
I
court
will
will
direct
consider-
it to remand the matter to rehear that application in
Yes.
accordance with law.
Yes,
That's all.
that's
And,
all, that's all.
Further, you want to file something, that's your prerogative, if it can be allowed. In
If it is
law,
permissible.
correct. So I'll just resume
I
in
may-
5 minutes and I'll give the order.
my lord,
Lima. Yes.
one my prayer is that non-disclosure of cause of action and other, I may get chance to agitate on that also.
You see, whatever is available in law is available.
And
You
actually,
want
your
to
lordship,
agitate, you file,
Your-
you want to file a subsequent application under Order 7, Rule 11, you file.
at
that is
any stage I can file.
Yeah,
Your
you
lordship
can
will,
file.
your lordship will appreciate that in this case, your lordship, while the TS 1/10 was rejected, they would have come for appeal. They have gone for review. The same party, same cause of action, again, they have filed this TS
review is
1/10.
pending?
No. One of is possibly referring to one of 2009.
Oh, acha.
One of
One in
2009,
2009 was
same
rejected.
party.
Mr. Counsel, you see, this court is now not considering CS 1/9. What has happened, not happened,
That
I am
I
not
get.
going into it because what is challenged before me is the order passed in your application, which was filed in 11D, but which was treated as it was filed under 11A. How that could have been done? When you have not pleaded non-disclosure of cause of action? That appears to be absolutely perverse.
Absolutely perverse.
That is, I can stop it there and I can just, but you see, I'm exercising the
Yes.
appellate jurisdiction under the order 41. So I have, in case I come to that finding, then I must remand it back also.
Yes.
That is why I'm saying I'll remand it back for a
Yes.
fresh consideration.
Yes.
That's all. I'm not doing anything more.
Yes.
I'll resume in 5 minutes.
Yes. যাও আরেকবার আপনার সেটের ফিস আপনার আরেক সেট ফিস এদিকে তাদের আরেক সেট ফিস তাড়াতাড়ি এসো এই মানে যে মানে আমি কইছিও তাহলে খুব বাজে ভাবে তৈরি করা হবে খুব বাজে ভাবে তৈরি করা আর ওটাই তো ইলেকট্রিসিটি তো আমার চার্জ করার দরকার যদি ভারতীয় না তোমার দিয়ে দিছি না এটা প্লেনটা খুব বাজে করে যাই না আমি কে করছে উইথ অল রেসপেক্ট টু দি ম্যান আমি জানি না উনি কিরকম পারতো কিন্তু দিস ইজ সার্টেনলি নট দ্য ওয়ে আই উইল অ্যাপ্রুভ দ্য প্লেন retake রিটেও যদি যায় রিটেক গিয়েও তো আলটিমেটলি ঘুরে ওই জায়গা থেকে রিমান্ডেড কেস ও আচ্ছা কি নাম তোমার শুভনীল হ্যাঁ শুভনীল শুভনীল আচ্ছা কতদিন ও মানে মাত্র দেওয়ার বলছে
মানে আমার এটা বই আছে
আমরা তো প্রফেসরে কেউ আইতো না
না আমার তো একটু যাচ্ছে না
হ্যাঁ
আমরা দুজন ফ্যামিলি
এটাই বলতেছি
আরেকজন আছে এমএমএম করতেছে ও ইউনিভার্সিটিতে ছিল
না এখন প্র্যাকটিস করতে ওটা ওইদিকে কালকে আমরা প্র্যাকটিসের যা অবস্থা হয়েছে না আমার ছেলে মেয়ে তো কেউ প্র্যাকটিস আর আমি যেহেতু তারা চাইছে না আমি এনকারেজও করছি না কারণ না এখানে প্র্যাকটিসের প্রসপেক্টও নেই আমরা আউট কাছাকাছি কোনো জায়গায় বা বাইরে তাহলে
আমি আমার পার্টিটা আগেই দিচ্ছি
প্লাস্টিক ফোন তো এরকম বাসায়
বাবা মারা গেছে দেখতে মানে
কিন্তু ফোল্ডার করে আসবো
সিভিল নাই আমার সঙ্গে তো হাইকোর্টে করছে বা কেন
তখন শিলংতে দেখে আপনি শিলংয়ে
তো না এমনি চাই কেমন দোকানদার থাকে
ওইটা আইসে কিনা আমার আইটেম নাম্বার 4 আইটেম নাম্বার 4 আইটেম 4 একটু কাগজটা নিতে হবে যাই যাব রেজিস্ট্রি করা না রেজিস্ট্রি করা আইসে আইসে হয় 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 কি মেইন আছে আমার তোমার প্রতি তো তুমি চলে গেল বাকি না
বড় এবার তোমার তেল বেড়ে গেল
admitted the RNTC
জানুয়ারিতে বন্ধ রাখবো
না
জানুয়ারিতে কোনো একটা ডেট দেখতে হবে গেলে
দেই তখন যেমন
এখন তো
যখন খুশি দেই
না এখন তো ভ্যাকেশন হয়ে যাবে না আমাদের তো ভ্যাকেশন কিন্তু মানে শিলংয়ে ডিসেম্বর থেকে ভ্যাকেশন শুরু হলো ডিসেম্বর থেকে ভ্যাকেশন লং ভ্যাকেশনের কথা
আমাদের 15 তারিখ থেকে 16 তারিখ থেকে জানুয়ারি থেকে রোগীর বলে
এক মাসের বন্ধ জানুয়ারির পরে গভর্নমেন্ট অফ নাগাল্যান্ড ক্যালেন্ডারে মানে দোকানগুলিতে তো এই সাবঅর্ডিনেট জুডিশিয়ারি ক্যালেন্ডার তো হাইকোর্ট থেকে কিছু হয় তো শোনালে
ফিল্টার বানানো আমি
আপনি মানে সুটটা কি প্রদীপ চলাইলো সুটকে চলে
This appeal is under 96.
No, 96.
This is item number 6. Heard Mr. S. Dr. Learned Senior Counsel, assisted by Mr. V. Devnath. Top Learned Counsel for the petitioner, for the
Appellant.
appellant. Stop. Also heard Mr. S. Paul.
PB
No,
Paul.
PB Paul, Learned Senior.
Not senior.
Learned Counsel for the respondent this government counsel also here. For respondent number.
Arbitration.
My learned friend is representing respondents from 1 to
Not
12.
No.
Huh?
1 to
Respondent
1 to 12.
1 to 12.
12.
Yes.
1 to 12.
And the others?
They are pro forma, my lord. We took steps,
to
they
12.
did not appear.
Stop. This is an appeal under Rule 29 of the Rules for Administration of Justice and Police in Nagaland, 1937, as amended, read with Section 96 of the Code of Civil Procedure, against the judgment and order dated 29/4/2011, passed by the Civil Judge Senior Division Number 1, Dimapur, Nagaland, passed in CMC number 25 of 10, arising out of title suit number 1 of 2010, dismissing the miscellaneous case as infractious.
Allowing the miscellaneous.
Type this then. Your cause title,
Oh, I'm so sorry, my lord.
instead of, don't say dismissing, arising out of so and so, comma,
This is
rejecting the
TS number to allowing the miscase and rejecting the TS one.
allowing miscase by rejecting the TS number 1 of 2010.
Yes,
Correct. So you saw your cause title.
yes, my lord, it's a transferred brief, my lord. So many things.
Yes. The facts of the case is that the appellant had filed title suit number 1 of 2010 in the court of the civil judge within bracket senior division, Dimapur, Nagaland, praying for, amongst others, declaration and confirmation of occupational right, title, and interest over the suit land, comma, to declare the grant stroke permit dated, VDA number LRPER DB 573-76 capital A dated 22/63, passed by the competent authority as lawful, effective, operative, and enforced to declare initial lawful occupation and enjoyment of possession and otherwise right, title, and interest of the appellant by virtue of landholder rights, etc., with absolute occupation and enjoyment as legal and substantive, comma, for declaration of impugned rectification order, VDA number 10, REV-2-2010-D-220-24 dated 7/4/2010 of the subordinate revenue cum resettlement officer Dimapur as bad in law and inoperative against the petitioner stroke plaintiff. Stop. Just say you'll get this at page 6 of the appeal. Huh? Just check. Pursuant to the filing of the said title suit, comma, upon notice being issued, the respondent stroke defendant preferred an application being CMC number 07 of 2010 before the trial court under order A7, rule 11 within bracket D. Read-
I'm sorry to interrupt, my lord. This CMC 07 of 2010 was perhaps renumbered as 25. Because in the order sheet, your lordship will find number 25.
All right. CMC number 07 of 2010 within bracket renumbered as CMC number
25 of 2010.
25 of 2010. You check, Mr. Paul, if that is correct.
Yeah, in the order sheet, my lord, it
All
is
right, you
reflected
point
as.
it out at the end of the order.
Yes.
Yes, Chair. Read with, have you written that? Section 151 of the CPC 1908 for rejection of the plaint filed by the respondent stroke plaintiff in title suit number 1 of 2010. Stop. The trial court by judgment and order dated 29/4/2011, after hearing the parties, was pleased to by rejecting the plaint. Stop. In view of the order passed in CMC 25 of 2010, the trial court was further pleased to direct by order dated 29/4/11 in TS number 1 of 2010 that the same has become infructuous and accordingly dismiss the same. Aggrieved by the aforesaid orders of the trial court, allowing the application of the respondent stroke defendant file under order 7 rule 11 and dismissal of the suit, the present first appeal has been preferred. Stop. Mr. Datta, learned counsel for the appellant, submits that the judgment and order of the trial court in allowing the application for rejection of the plaint on the face of it is perverse and is liable to be interfered by the appellate court. Stop. He further submits that though the application filed by the defendant respondent was under order 7 rule 11D, the trial court considered it as an application under 11A and dealt the matter, which is totally perverse and amounts to violation of natural justice, as the appellant did not get an opportunity to contend that the plaint discloses cause of action. Stop. These are the two main arguments.
Yes.
Per contra, Mr. So-and-so Paul, learned counsel for the respondent defendant, submits that, don't say per contra, fairly submits that though the ground taken in the application, taken in the miscellaneous application ICMC number 07 of 2010, within bracket renumbered as CMC number 25 of 10, 25 of 10, is as regards the plaint being barred under law, the trial court, instead of considering the same, has considered the matter under 11A, which is non-disclosure of cause of action. Stop. Heard, perused. the point of determination that arises in the present appeal is whether the trial court could have converted the application filed by the respondent defendant under Order 7, Rule 11D to that of Order 7, Rule 11A. Stop. Correct, Mr. Datta?
Yes, yes.
This is the point of determination?
Absolutely.
Because I have to
Yes.
give the point of determination in my decision.
Yes, and the reasons also.
Yes. But that is the point of determination, isn't it?
Yes.
In order to,
The Order 41 also says that appellate court has to record reasons.
yes, contents
Ah,
of the judgment. Before adverting to the point of determination, comma, pertinent to mention that the appellant, before filing the present accompanying, before filing TS 1 of 10, comma, had filed CS, I have it, filed another suit in the year 2009, which was registered and numbered as CS 1 of 2009. Stop. In that suit, the defendant respondent had filed an application under Order 7, Rule 11 for rejection of the plaint, which the trial court, after hearing the parties by judgment and order dated 22/11/2009, was pleased to allow the application of rejection, was pleased to reject the CS 1 of 2009. Stop. The present suit was filed thereafter.
In between on review petition was also filed.
Stop. In pursuant to the order of rejection, comma, it appears that a review petition being
One of the
review petition number,
review case number 1 of the
review case
2010.
number 1 of 2010
Yes, Your
was also filed by the appellant. Stop. What happened in that?
21 rejected.
Which was subsequently rejected by
21/4/2010.
judgment and order dated
21/4/2010.
21/4/2010. Stop.
the review petition is at page
It
128.
appears that in the present suit also, no, it appears, don't say it appears. In the present suit also, comma, the respondent defendant had filed an application under Order 7, Rule 11D for rejection of the plaint. Stop. Paragraph 3 and the grounds taken in the aforesaid application are reproduced hereunder for ready reference. Paragraph 3 I have tick mark is at page 210 and the grounds starts from 210 A, B. I think A, B till G, right?
Yes.
Gift ABC to G, huh? Page 2013.
Only one thing, my lord, subject to correction. In the CS 109, 1 of 2009, it was Order 7, Rule 11A, not 11D.
Acha. All right, I will add this. I'll add it.
Order CS 9 is
In CS 1, you
11A
have said an application was filed, that is Order 7, Rule 11A, huh? In CS 1 of 09. Otherwise, I will give it later. Don't
Yes.
worry. I'll edit the order. Yes. After this, you're right. Before adverting, pertinent to refer to Order 11, Order 7, Rule 11, which is reproduced hereunder for ready reference. Order 11, Order 7, Rule 11, You quote unquote, huh? The entire thing at page 182. Now you write, apparent that the power and jurisdiction of the court to reject a plaint is when the plaint does not disclose a cause of action and or where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time. No, don't say all that. It's not that is not relevant. So you say the power and jurisdiction and of the court to reject a plaint either under subclause A of order 711 is when the plaint does not disclose a cause of action, and or under subclause D of order 7 rule 11 where the plaint where the suit appears from the statement in the plaint to be barred by any law. Stop. In the present case, the application for rejection of the plaint was filed under order 7 rule 11D. Stop. Which is where the suit appears from the statement in the plaint to be barred by any law. Stop. Accordingly, where did you file your objections? Accordingly, the plaintiff stroke appellant filed its objection. Yes, where is it?
That objection, your lordship, will find at page 227. 227.
Objection.
Written statement.
File a written statement against in the said file written statement stroke it should have been objection.
Yes.
Stroke objection against the said rejection application filed by the respondent stroke defendants, wherein the appellant contended that
particularly your lordship may refer to paragraph B at page 235.
Contended that the suit is not barred under any law. Stop. Paragraph. Which paragraph you want me to quote? Paragraph B.
If your lordship pleases. Huh? If your lordship pleases, your lordship can refer to paragraph B, page 235. Where specifically it was pleaded that it is not barred.
Paragraph 6 is paragraph 6
B.
A and B is paragraph 6 C B. Huh? Paragraph 6B is reproduced here under for ready reference. A to A at page 235. However, it appears that the trial court considered the application filed by the defendant respondent under order 7 rule 11A instead of rule 11D. Stop. Reading of the judgment of the trial court appears that the trial court has not considered whether the statements made in the suit, made in the plaint is barred by any law. Stop. It appears that the trial court, without there being any pleading as regards the plaint not disclosing any cause of action, has suo motu taken up the issue and decided the same against the appellant.
Yes.
Stop. The said course adopted by the trial court at the very outset appears to be perverse, inasmuch as the appellant has been totally deprived of the opportunity to show before the trial court that the suit discloses cause of action. Stop. It further appears that the trial court has also held that since the plaintiff had filed CS1 of 2009 on the same facts and issue, which was rejected by the trial court and thereupon confirmed by the review court, comma, the suit comma, this court, the trial court has no jurisdiction to entertain the present suit. Stop. It appears that the issue of rejudication is also not taken by the respondent defendant in the application for rejection. But notwithstanding the same, the trial court on its own have rejected the plaint on the ground of res judicata. Stop. Reading of the grounds of rejection as stipulated in Order 7, Rule 11 appears that the same is not one of the listed ground. That being so, the order of the trial court rejecting the plaint of the appellant on that score also is perverse. Stop. That's all.
Yes.
In view of the above, this court is of the considered opinion that the order of the trial court dated 7/4/2011, order or judgment and degree it is called.
Actually, it ought to have been written as judgment and degree,
But here it's saying order.
but they have written it as order.
So what should I refer it as?
Your lordship may say that the orders, judgment and order.
Judgment and order dated 7/4/2011 and subsequent order dated 29/4/11 of the learned civil judge, senior division, Dimapur.
No, my lord, it will be 29/4/2011. Both orders are 29/4.
All right. Orders dated so and so of the civil judge, senior division, Dimapur, Nagaland is illegal and is hereby set aside and quashed. Stop. Stop. However, since the application filed by the respondent defendant under Order 7, Rule 11D was not considered by the trial court, comma, the matter is remanded back to the trial court for fresh consideration of the said application in accordance with law. Stop.
Yes.
That's all.
Only thing, my lord, if your lordship can insert that judgment and order dated 29/4/2011 in CMC number so and so, and order dated 29/4/2011 in TS number. So
That will clarify.
yeah, that will clarify.
Say judgment and order dated 29/4/11 in CMC 25/10 and order
Dated
dated 29/4/11
in TS number.
TS number 1/10
Yes.
are illegal and hereby set aside. Okay. Trial court records be accordingly returned.
Your lordship can fix a date for the appearance of the parties, or
That's all
if-
right.
or if the trial court may be directed to notify the
Trial,
parties.
upon receipt of the case records, may intimate the parties the date of listing. No, but that date of listing, or what do you say?
Notify the appearance of the parties.
Notify the date of appearance for the parties to do the needful.
Much appreciated.
You may file whatever you want to file in
Yes.
petition, disposed of.
For admission, item number 4.
This you will need you. Yes, records have come.
Yes.
You must keep this there. Yes. What is there in the records?
Lordship is directed.
Joint
by the-
verification.
Lordship.
Yes. What did you find?
Lordship is directed by this honorable court on 4/10/2024.
Mr. Devnath, you will not get this order today. You'll get it next week, huh? Mr. Paul, you are also there in that matter,
Yes,
right?
yes.
So don't expect the order today because it appears that I have disposed of couple of matters, so they will take some time. So
Matter is
there-
lingering since 2011.
Yeah, but you will get it next week. You'll get it on Monday.
No problem for that.
Today it will be difficult because there are 5-6 bail matters also. All right.
Lordship, I have stated in the page 2 of my affidavit.
Upon
Lordship.
inspection, it was
Lordship.
observed that the structural integrity of the main so-and-so was compromised and it needed repair.
Lordship.
Furthermore, your opinion so-and-so. And you said you have no objection,
Lordship.
so I'll allow it.
Lordship.
Yes, please. Heard, please give the parties' names, huh? Heard so-and-so, also heard so-and-so. By way of this application, comma, the applicant is seeking direction for allowing the applicant to undertake repairing works of the dilapided gate of etc. of the premises tends on the land covered by Patta number 1368 under DAG number 1425 of Dimapur town block number 7. Stop. This court earlier by order dated pertinent that this court earlier by order dated 4/10/2024 sorry, not 4. Earlier by order dated 17/9/2024 directed the Deputy Commissioner Dimapur or the authorized officer stroke representative to verify as to whether the repairing sought for by the applicant is necessary. Stop. Order relevant portion of the order dated 17/9/2024 is reproduced hereunder for ready reference. B2B, huh? The respondent number. Respondent number 2. Respondent number 2, I, Deputy Commissioner, by filing an affidavit
Uh,
7/11/2024 has brought on record the verification report as directed by this court by order dated 4/10/2024. The verification was directed by 4/10.
Verification was directed on 17/9/2024.
Then
And
4/10.
on 4/10/2024, this honorable court has directed the state
file the
court
affidavit.
to file affidavit in the
Okay,
form of
okay,
affidavit.
So in between, then you say that pertinent that on 4/10/2024, when the matter was listed, comma, learned state council submitted that the verification report as directed by this court earlier has been done and the same has been received. Stop. In view of the aforesaid endorsement of the learned state counsel, this court directed the respondent to file the said report by way of an affidavit. Stop. Thereafter you said, accordingly, so and so has filed, okay? It appears from the, no. The verification report as enclosed to the aforesaid affidavit, verification report dated 30/9/2024, is reproduced hereunder for any reference. C2C, page 10. Perusal of the said report indicates that the repairing works as sought for by this interlocutory application is necessary. Stop. Pertinent that, Mr. Your name?
Lordship.
Huh?
Alipa
So and so learned counsel for
the opposite party petitioner.
For the opposite party stroke petitioner fairly submits that he has no objection if the aforesaid repairing works as sought for under the interlocutory application is allowed. So then you write, in view of the verification report as well as the endorsement of the learned counsel appearing for the petitioner stroke opposite party, this court is of the considered view that the interlocutory application warrants to be allowed. Accordingly, it is directed that the applicant be allowed to undertake repairing works of the main gate and cover the lift shaft on the building standing on the land covered by patta number 1368 under DAG number 1425 of Dimapur town block number 7. Stop. Correct? That is all?
Yes.
Applications stands allowed, disposed of.
Lordship,
Yes.
may I, sir? Limited time may be given, 2 weeks time
For
to
what?
complete the repairing works.
It is in their interest.
We'll do it another, otherwise,
It is they who have come. I'm sure they will do it soon.
otherwise if it falls down, it will cause accident and
Correct.
will be again under vigorous liability of.
Why to
Lordship,
unnecessarily?
I'm concerned that at the critics of repairing, they might take extra time.
All right, I will add in that. It is needless to be clarified that the aforesaid repairing works shall be completed within a period of, take it 1 month,
1 month, your lordship.
within a period of 1 month from today.
My client used to be, he's a doctor. he used to
I'm
be-
giving you 1 month
Yes, much obliged.
because he's right.
Yes.
He should not be prejudiced in the name of repairing work.
Yes, yes.
He's being fair. Anything left?
Lordship, in the mandate petition, there is an interim, if that may be.
In the
continued.
main petition, you say list after 3 weeks
Yes.
Yes.
on a date to be fixed by the registry, and interim, if any, shall continue till the next date of listing.
Highly obliged.
Thank you. Thank you.
Do not.
Asal talaga pwede tayo wala na. Principal si Caro ba na enrollment na.
I do dispose now. Our main is to choose.
Tayo nagpapang ko yasa yun. Marami yung explain ko dito. Because it's not so much. Why you explain? We better explain.
My phone only one, two, what was it? I did. I did. Then
Hello.
Port 2 3 ಹೋಗು.
Now apply for civil these also. Berita mengambil sepuluh barang kena sampai ke memari ini bisa next memari nakal ya oleh bawah ini namanya politik ini sampai
Rejection na, 14 na. Oh, itu kayaknya harus kita aja. Dia dapat TV ba,